Now, it wouldn't be law talk if we didn't have a disclaimer. So there we go. It's my own private views. It does not in any way reflect the views of my employer, nor does it influence or reflect any work that I do within my employment. Also, it's not legal advice. If you are coming to a conference to get legal advice, that's very foolish. I'd suggest that if you do have a copyright problem, you speak to a lawyer, because every problem is different. So I'll just give you a bit of a rundown of what we're going to talk about today. Now, hopefully I've managed to purge all the law words out of this presentation, but some may have got through. It's designed for non-lawyers. If I say something that you don't understand, please put your hand up and say, what does that word mean? Obviously, we're going to need to talk a little bit about the law, so some law words may have got through. It's basically in 4 parts. We're going to talk about the Australian Law Reform Commission interim discussion paper that was released early last year. Then we're going to talk a little bit about the fair dealing exceptions in Australian copyright law. Then we'll talk about the issue of fair use, the government's position on this. And as I said, questions are fine, particularly if it's just a clarification question. If you've got a longer, more detailed question, you might leave it to the end. I've left some time there for that. So, Australian copyright. There have been several recent important copyright cases in Australia, 2 of which I spoke about. The Kookaburra case, which is what we're going to use today, is a bit of an illustrative case for the fair dealing and fair use in the presentation today. There was the IINet case, which was secondary liability of ISPs. Won't really touch on that one. And the Optus TV Now case, which is basically about the private and domestic use exceptions in Australian copyright law. We'll touch on that as well. Now, Australian copyright law deals by exception. So there are a bunch of exceptions called the fair dealing exceptions, and you need to fit your use of copyright material under those exceptions. There's time and format shifting exceptions as well. So it's not like the US where they have a general fair use defence. So in June 2012, because we've had all these major changes to copyright law through these various cases, the previous government asked the Australian Law Reform Commission to examine Australian copyright law, and specifically they asked them to look at whether a fair use defence would be appropriate. So here are the terms of reference, or some of the terms of reference that we're going to talk about today. The ALRC was asked to look at whether we need to recognise fair use of copyright material or allow transformative, innovative and collaborative use of copyright materials to create and deliver new products and services to the public benefit, and allow appropriate access, use, interaction and production of copyright material online for social, private or domestic purposes. Essentially what that means is, should we have some more exceptions in the copyright law, or should we use fair use as a general defence? And we'll talk about these. The report that came from the review was submitted to the Attorney-General in November of last year. Unfortunately, Parliament was no longer sitting at that time, and so the 15 parliamentary sitting days to table the report have not elapsed, so we haven't seen the report, and we haven't seen what the government's comments on that report are. So we'll talk a bit about the interim discussion paper that was released. It pretty much gives the kind of direction that the ALRC was thinking. So as I said, we're going to use the Kookaburra case as an illustrative case for the fair dealing and the potential defence of fair use. Now, does everyone know the song Down Under by Men at Work? I'm not going to sing it, even though I threatened to. And does everyone know the Kookaburra song? Everyone went to primary school in Australia? You can probably remember singing that. As you can see, it's a very old song, 1932, but because of the rather long period of copyright term, it's still under copyright. And Down Under was released in 1981. Now, in 2007, a musical quiz show called Spicks and Specks had a question that referred to the flute riff in the song Down Under. They said, what is the other Australian song that is contained within Down Under? And if you know the songs, you'll know that the flute riff it's quite difficult to pick out the Kookaburra, but it's definitely there. And they basically answered the question correctly. Yes, Kookaburra's in there. This was in 2007, so a long time after these songs were actually written. And so, of course, what happened? The record companies went to court over it. Now, the actual case, it's interesting. It's got a lot of sort of esoteric issues about ownership and that sort of thing, which really don't impact on this particular presentation. But it was found that Down Under used a whole or substantive part of Kookaburra, and therefore it infringed on the copyright of Kookaburra. Now, in Australian law, basically you're not allowed to use any more than a whole, if you use a whole or substantive part and you don't have a license, it's infringement. It's not like in the US where you've got fair use. So it didn't actually change the law at all. In fact, it's pretty, it pretty much follows Australian law in this area. But it was an important case nonetheless. And it was important because of the reaction of the public and of the musical community to the finding. Because it took two culturally significant songs in Australia, Kookaburra and Down Under, and it mashed them together. And really the subject matter of Down Under was, like I said, culturally significant. And as Justice Emmett pointed out, the quotational reproduction of the melody in Kookaburra appears by way of tribute to the iconicity of Kookaburra and is one of a number of references made in Down Under to Australian icons. So it was really all about lots of Australian things, including Vegemite. And obviously references to trademarks because of the way that trademark law works, that's not an infringement. However, the reference to Kookaburra in the same sort of way was copyright infringement because of the way that copyright works. And so it really clashed the ordinary use of works, the sort of view that the general public has of the way that, what's fair to use as far as copyright is concerned, and the sort of hard-nosed legal view, which is that it's infringement. So, as I've mentioned before, the US has a general fair use defence. So if the use is fair, then you've got a defence against infringement. However, Australian Copyright Act only deals by the exception, so there is a presumption of infringement unless you can fit it under one of those exceptions. And they're known as the fair dealing exceptions. So what is fair dealing? Well, as you can see, it's a fairly limited list of things. You've got to fit it under one of those exceptions and the use has got to be fair. So we've got exceptions for research and study, criticism or review, parody or satire, reporting the news, and some stuff for lawyers. And it also has to be fair. And so when we're weighing up whether it's fair, we look at the purpose and the character of the dealing, the nature of the work, the possibility of obtaining the work for a licence at an ordinary commercial price within a reasonable time frame, the effect of the dealing or recording upon the market for or the value of the work, and the amount and substantiality of the part of the work that has been used. So we weigh up all those factors and work out whether it's fair, but you need to fit it under one of those exceptions first. So, there's a whole heap of things that we might think in the ordinary course of dealing are fair, but are not. Well, they're not fair dealing at least. So sampling, that's right out. Non-commercial use of incidental music, you stick some music in the background of a YouTube video, that's probably infringement. Transformation of copyrighted work, except for parody or satire. Now, Kookaburra really was a transformation, or Down Under was a transformation of the song Kookaburra, but that's not a fair dealing. Memes, those stuff that you might share around on Twitter or Facebook, they're probably infringing copyright. Commercial services to allow recording in the cloud, that's a TV Now case that was decided a couple of years ago. Storage of copyright material in the cloud, potentially. Optus TV Now case made that a little dicey. We can't copy a DVD to other devices. However, if you do have a copy on VHS, that's okay, because you can actually do that. It's a very specific exception. So any of those old 80s movies you can put on your computer. Things that search engines do, probably a good example is things like thumbnails, probably infringement. And digital archiving. It's actually quite difficult to archive things digitally. It's fine if you print it out, stick it in a folder somewhere in a dusty archive room, but if you try and do it digitally, you can run into all sorts of problems. So you normally think that was fair, but they don't fit under those exceptions. So should we have more exceptions? And I'm going to look at 3 different types of exceptions that the ALRC was asked to look at for quotations, transformative use, and private and domestic use. And then we'll talk about, is it better just to have a fair use defence? So what about an exception for quotations? Well, the Berne Convention, which is sort of the granddaddy of international copyright treaties, has an exception for quotation. So it says you can have an exception for quotation. But that really does require a very expansive use of quotation. When I say I quoted him, you usually think, well, you've actually used the term verbatim. it's not really otherwise you'd say I paraphrased him. So it does require quite an expansive use of the term quotation, and it doesn't really cover transformation because it does imply a verbatim use. So you're kind of relying on courts to take a very expansive view, and you probably don't want to do that because they're just as likely to take a narrow view, and that kind of takes the meat out of it as an exception. But let's have a look at what it might look like as an exception. Well, you'd probably look at the purpose of the particular quotation that you're using. And Justice Emmett also pointed out in the Kookaburra case that the better view of the taking of the melody from Kookaburra is not that the melody was taken in order to save effort on the part of the composer of Down Under by appropriating the results of Miss Sinclair's efforts. Miss Sinclair was the one who wrote Kookaburra. Rather, the quotation or reproduction of the melody of Kookaburra appears by way of tribute. So that's probably a purpose that would fit very well under this exception if you had a broad view of the term quotation. If you were just grabbing a piece of work and sticking it into your song to save trouble, that probably wouldn't work. You'd also need to look at the fairness of the quotation, probably using those fairness factors. You need to have sufficient acknowledgement of the quotation, and in some types of artwork that's going to be quite hard. It probably works better as an example of fair use, and because of the sort of requirement for it to be quite an expansive use of the term quotation, it is difficult as a standalone exception. So what about transformation, which is what Men at Work did with the Kookaburra song? Well, the ALRC says the transformation is the use of a pre-existing work to create something new that is not merely a substitute for the pre-existing work. So things like mashups and remixes and the like. Now in the US, because they've got this fair use defence, it's actually just an example of what might be considered a fair use. And I've got a quote there. Basically they say that the transformation works lie at the heart of the fair use doctrine's guarantee of breathing space within the confines of copyright. So, as I said, it's an example of fair use rather than a standalone type exception. But what would it look like as an exception? Well, you're going to run into problems. If you have a low threshold, that is, we just create a new work, so we tweak things a little, and that's a transformation, you are undermining the creator's rights. Basically, you only need to tweak it a little bit and all of a sudden you've got something that you can use. If you put a high threshold on there, well, where does that cut in? How much change do I have to do? Was Kookaburra changed enough to be a transformative work, or is it more a copy? So you run into those sorts of problems. Now in Canada, they've basically gone down the path of the exception route and they've put a low threshold on there, but they've said, look, only for non-commercial use. We're going to have all sorts of problems with non-commercial use. You put it on a website that has advertising on there, is that commercial use? If you share it through Twitter that you use to promote your own professional services as well as sharing memes, is that going to be commercial use or not? It's difficult to say. And I think the Australian Communications Consumer Action Network put it quite well in their submission to the ALRC. There is little to be gained from having courts applying themselves to assessing mashups or a remix to ascertain whether they fall within a tightly worded exception when the real issue is whether the use is fair and the extent of harm to the creator. So it's a very difficult exception to really play out. So what about private and domestic use? Well, currently we've got a couple of examples of private and domestic use that are in the Copyright Act, format shifting and time shifting. As I said, only analogue for format shifting, so your VHS tapes are safe, your DVDs, you have to just have them on DVD. Time shifting, devices in the home are okay. As soon as you move it into the cloud, that's a real problem, as the TV Now case showed. And storage and access from commercial cloud services, that's quite uncertain. It's really not a technology neutral exception, which is unfortunate. But how would we look at it as an exception? Well, the Canadians, like I said, have gone down that path. They've put in a generic time shifting and format shifting exception. But of course yeah, sorry?
So just a question on that.
Yep.
The digital. So is there actually a word, like the wording so that it says that you can only do it to analog and not digital? That's specific.
Yep. So the question was, is the drafting of the exception in the Copyright Act so specific that it only has analogue and not digital? Yeah, it is. Yeah, it's really poorly drafted. So the Canadians have gone down that road, and they've made it a general technology neutral format and time shifting exception. But of course, when you get into those commercial services that do that time shifting and format shifting, you might run into problems. They also have an exception for social uses, but again, it's that non-commercial social use. So, as I said, if you're advertising particular professional services through Twitter and you also like to put out something funny every now and again for your customers, and that's using copyright material, is that a commercial use? Maybe, you don't know. So the exception model that Canada's gone down, I think it creates quite a bit of uncertainty around some of these services and is still quite narrow. So what about fair use? Well, fair use is a defence to infringement, and it asks the fundamental question, is the use of the copyright material fair? What does that mean? Well, we'll go to the US Copyright Act. And really, the thing I want to point out there is not the sort of header text there, it's really those fairness factors. Again, it's the purpose and the character of the use, including whether such use is of commercial nature, the nature of the copyright work, the amount and substantiality, the effect of the use upon the potential market. Does that sound familiar? I think that sounds like the fairness factors that we have in our Act. And you'd be right. So what's it going to look like in Australia if we decide to go down that route? Well, you probably have those fairness factors, and you probably take the ones from our own Act or use the US ones. You'd have illustrative uses, and I've talked about those, transformation, private and domestic use, quotation, a bunch of others. As in the US, it'd be a non-exhaustive list, so you can make it quite flexible. And that means that you're just weighing up the factors, which does make it quite a flexible exception. You can see that in the US, where various fair use cases, it's all about weighing up those factors. So as I said, it asks the question, is it fair? And that means that you can better align it to community expectations. The Kookaburra case, classic example. People thought that use was probably okay, and it was okay for many, many years until the Spics and Specs episode pointed out that it might have been an appropriation of another song. It allows innovation. It's technology neutral. You don't have to talk about whether it's digital or analog or anything like that. Really, the question is it fair? It doesn't really matter what technology you use. It balances the interests of consumers of copyright material and creators. And because it's non-exhaustive, it's very, very flexible. So as I said, it allows you to more easily align it to community expectations. And we can see that in, as I said before, the transformation of musical works in Kookaburra. Now this quote from Paul Kelly, another Australian musician, it's actually not from the ALRC reviews, it's from a doco. But I think it sort of sums up the music industry's view quite nicely. In blues, folk and country and soul music, the building blocks of pop, words, lines and whole verses have been swimming around forever from song to song. Melodies too. I remember when sampling first became popular with the rise of hip-hop, and a lot of musicians I knew who prided themselves on being able to play their instruments properly were dismissive. They said, that's not music. They sniffed, anyone could do that. But sampling made perfect sense to me. I'd been doing it since I first started making songs. And I think a lot of musicians really do view music that way. I mean, I play a musical instrument. I've written songs before. And yeah, you obviously appropriate other melodies and that sort of thing. And as the EFA pointed out, many Australian consumers, when the limitations of fair dealing exceptions are explained to them, roll their eyes in disbelief that the law insists that such things that they consider legitimate everyday activities are in fact illegal. Discussions on this topic tend to ridicule the law, and that's never a good thing because it means that people won't follow it. If they think it's stupid, they won't do it, and that doesn't help anyone. Fair use also encourages innovation. As Yahoo pointed out, under Australia's existing copyright regime, very many socially useful and economically beneficial technological innovations would simply have no breathing space to emerge. They would be blocked at the first post by a copyright regime that is insufficiently flexible to accommodate technological innovation. And even when a large company like Optus can put out a service like TV Now and have that chopped off at the socks, if you're an independent application developer, you're really going to be out of luck. Application development can thrive in Australia if there is a broader approach to how content can be used by others, while still ensuring that such use does not deprive the rights holder of a legitimate revenue stream or impact the market value of the underlying work. So again, Yahoo's pointing out, look, it's really about whether it's fair. It's one of those fairness factors, the effect on market value. Now, fair use also promotes balance in copyright, because it's all about weighing up those factors and asking the question, is it fair? The Joint Standing Committees on Treaties, when they were examining the Australia-US Free Trade Agreement, which extended copyright extensions quite a bit, they recommended that the Australian doctrine of fair dealing should be substituted for the American doctrine of fair use, because it would counter the effects of the extension of copyright protection. So the Joint Standing Committee on Treaties is pointing out, look, you know, we've gone a long way towards protecting copyright interests. We might need to balance it out by having a much more flexible situation. And the Australian Consumer and Competition Commission pointed out that an exception like this is likely to promote an appropriate balance between socially beneficial incentives to create and incentives to disseminate and use copyright material. So the government regulator for consumer stuff basically agrees that it does provide balance. It's also quite flexible. Now, the current law has a closed list. As I said, you know, those fair dealing exceptions, you've got to put it under there. And as Telstra pointed out, the current exceptions are generally created in response to existing technologies, economies and circumstances. As a result, they tend to have a narrow patchwork application to circumstances existing at the time the exception is introduced. And we can see that. The time shifting exception, for example, introduced in 2006. Betamax, 22 years beforehand, fair use case in the US that essentially enabled the video recorder. Took 22 years of Australians busily infringing copyright to then have it introduced into the Australian law. So changes to the law are slow and generally fairly inflexible. Now, there are certainly arguments against the introduction of fair use in Australia. And in the ALRC submissions, one of the main things that they pointed out, the people who were against it, said that there was no case made out for the need for a fair use exception. I think I've probably made out a fairly good case. They also say it creates uncertainty because it shifts the power from Parliament to make exceptions in law to the judiciary to decide what's fair and what's not. And it requires litigation to determine what's fair use. It originated in a different legal environment. So the Americans, in their constitution, they actually have a bit about copyright. We don't have that sort of constitutional guidance. They also have 170 years of jurisprudence, including the last 35 years where they've codified it into their law. So it's a well-known doctrine in the US. They're saying you can't just sort of grab a well-known doctrine from somewhere else and stick it in Australian law. And they also argue that international law, the Berne Convention, TRIPS and the AUSFTA, which contain within them what's known as the three-step test, we'll get to that a bit later, they say it doesn't actually comply with that. So, does it really create uncertainty? Well, already in Australian law, you have quite abstracted standards and principles. So rather than sort of being very prescriptive about what you can and can't do, we have these standards and principles. And a good example is in Australian consumer law, in the course of trade or commerce, you're not allowed to engage in misleading and deceptive conduct. Now, that doesn't tell you what the conduct is, it doesn't tell you what you can and can't do, it doesn't have the exceptions or anything like that, but we have that sort of fairly abstracted standard misleading deceptive conduct. And it really is just the ordinary use of the word. Sure, there's been lots of litigation about it, but it's generally just the ordinary uses of the word. In unfair contracts, we actually weigh the factors of whether a term in a contract is unfair. So if we've got two organisations that they've got teams and teams of lawyers, and we're looking at a term in a contract, we'll probably say, well, that's actually probably not an unfair term because, you know, they've got the resources to make sure that it's fair. But if it's a company with huge armies of lawyers and an individual, that might tip the balance to sort of go, well, it probably is an unfair term. And if you want to look at the sort of ultimate abstracted principles and standards, you can look at the privacy principles. Now, the Privacy Act needs to regulate the entirety of the Australian public service and business. And obviously, there are a whole heap of very, very different ways and uses of information, reasons for collecting it. If you had to try and have a prescriptive list of things you can and can't do and reasons why you can pick up information and use it in particular ways, I mean, the Act would be enormous and horrendously complex. Sorry? It'd be even more enormous. That's actually not an enormous Act, gee. Look at the Copyright Act, look at the Tax Act. Oh. So they're quite abstracted. So it's not unusual in Australian law to have these standards and principles. And so a standard and principle of fairness is really very much along these sorts of lines. I think that argument tends to fall on its ear if you look at other areas of Australian law. Now they say also that it comes from a different legal environment. And while this is true, they actually come from the same sorts of common law roots. The Americans only codified it around, I think it was 35 years ago or thereabouts. Before that, it was all common law. And those fairness factors that you see in the codified American law, very similar to the fairness factors that we have in our law. So it's a bit strange to sort of say, well, it's all completely different. It's not. And I suppose to point out the obvious, when we entered into a free trade agreement with the US, one of the things it was meant to do was to harmonise copyright law, often in bad ways. But if you look at the FTA regulatory impact statement, they said the harmonisation of our laws with the world's largest intellectual property market will provide Australian exporters with a more familiar environment and certain legal environment for the export of value-added goods to the United States. Excellent. In turn, US investors will be attracted to the Australian market because of greater familiarity and confidence in our legal system. Sounds like a really good argument for importing fair use, because it's a very well-known doctrine in the US and it provides them that flexibility. So, to sort of say, well, it comes from a different legal environment, again, it kind of falls on its ear. Now, the other argument they make is about international law and international treaties of which we are a signatory. And there's the three-step test. So it says, if you're going to introduce exceptions into your copyright law, they need to be for certain special cases which do not conflict with the normal exploitation of the copyright material and do not unreasonably prejudice the legitimate interests of the rights holder. And the one that they tend to focus on is that certain special cases. They're saying fair use is not a certain special case, it's actually a really broad defence. And there's a lot of academic argument about it, but it is just that, it's academic. There are exceptions that existed at the time of negotiation. It is unlikely that countries wanted to actually extinguish their own exceptions by treaty. US fair use has never been challenged, and other jurisdictions have introduced fair use without challenge. So I think you might be able to make a case that it doesn't fit under certain special cases, but the practical implication is it's never really been challenged and it's unlikely to ever do so. So I think that argument is probably fairly weak as well. So what should it look like if we do import fair use into Australia? Well, the Australian Law Reform Commission said that the fair use exception should contain an express statement that fair use of copyright material does not infringe copyright. Well, that's a bit of a no-brainer. A non-exhaustive list of factors, so those fairness factors again, and a non-exhaustive list of illustrative cases. So things like transformation or quotation, those sorts of things. So what should the fairness factors look like? Gee, they look familiar again. Purpose and the nature of the purpose and character of the use, the nature of the copyright material, the substantiality of it, and the effect on the potential market. So those are those fairness factors that you see in the US law, and they're also the ones that you see in the Australian Act. And a non-exhaustive list of illustrative purposes. And these are just what the ALRC suggested. There's probably some more that you could add there. But like I said, it's non-exhaustive. You don't need to fit it underneath one of these things. And as you can see, all the fair dealing ones are there, plus a couple of extra ones. But of course, they're just illustrative uses. So you might have a use that is transformative, but it's not fair. So it's not like the exception where first you have to jam it under an exception, and then you've got to work out whether it's fair. Basically, you can point to the fact that it's a transformative use, but the question still is it fair? But it's much, much more flexible. So what's the government's position on this? Unfortunately, it hasn't been tabled in Parliament, so we can't actually see the government's reaction to the report itself, which is a grand pity because I would have loved to talk about it today. However, we can look at some of the statements, public statements that have been made by the government. Now, the Attorney-General, George Brandis, and the Attorney-General's Department, thank you for that. The Attorney-General's Department is the one that has responsibility for copyright. So George Brandis said to the Australian Directors Guild, "Whatever form those reforms take, I want to assure you, following from the observations I've just made about my own attitudes to intellectual property protection, that those reforms will not impinge on or violate the rights of content creators and the owners of intellectual property. They will be designed to further secure and protect those rights. Now, the emphasis there is mine because can anyone notice that there's one lot that are missing from there? Consumers of intellectual property? Yes, everyone else, that's right. The rights of content creators and the owners of intellectual property, they're the only ones that matter. That doesn't really bode well for the introduction of a fair use exception, so hopefully I'm wrong. The Prime Minister, Tony Abbott, has also committed to several free trade agreements, including the Trans-Pacific Partnership, and if you didn't see Sky's talk yesterday, I'd urge you to look at the video. Basically, the TPP contains quite a few intellectual property provisions, many of which are fairly hostile to the idea of fair use. So I think that that could be quite highly problematic, which is unfortunate. So, where do we go now? As I said, the ALRC report release is imminent. So the next parliamentary sitting is in February, so it'll be 15 days, and then it'll be tabled, and we will get the government's actual position on it. Well, they'll table it and they'll make comment on it. So we might have a bit better idea. It's very likely that copyright holders will and probably have been lobbying against fair use. And the government has shown that it's more responsive to business rather than consumer demands. Again, the Trans-Pacific Partnership is sitting in the background there, and that's probably fairly problematic for the introduction of an exception like fair use. It doesn't preclude it by any stretch of the imagination, but if you're going down the path of strengthening copyright and that's the sort of treaty that you want to sign, it's unlikely that ideologically you are going to put something in there like fair use. So it is unlikely that this government will legislate a fair use exception. It's much more likely that copyright will become more restrictive, particularly if the TPPA is signed. So what can we do? Well, there might be a Senate election in Western Australia coming up. Might be. The result has been declared, but it is in the Court of Disputed Returns at the moment, and the Court of Disputed Returns may order a fresh election. That'll be fun. So if this is important to you, you might like to look at some of the candidates and work out whether they are more likely to introduce a more flexible copyright regime or are not, and choose to vote for them. So it's definitely worthwhile, and particularly if you live in Western Australia, and if they do order a new election, because I mean anything could happen, the Court of Disputed Returns may just accept the result, or they may order a new election. But if there is one, certainly look at the candidates. And the other thing we can do is lobby. And as I said, Sky's talk yesterday talked about various techniques for doing that. You can contact your local MP, you can contact your local senator. It's often a good idea to call them rather than to send them letters. You might even want to organise a meeting with them. Sometimes, if they're a backbencher, they quite often will meet with you. And you can get your point across. And it's important, lobbying does actually make a difference. So what should we say to them? Well, in my opinion, the introduction of fair use defence would assist the Australian software industry because it removes that uncertainty. So when you're trying to use other copyrighted material or you're trying to have a device that does an innovative use of other people's copyright material, I don't know, like TV Now or like a video recorder, like the Betamax case, it means that you can sort of look at those fairness factors and you can judge whether that use is fair.
Was that fair use?
Sorry?
Was that fair use? Me taking a photo?
Yeah, sure. I can give you permission.
Thank you.
I think these are actually released under a fairly permissive licence, so that's fine. But I'll give you my model release as well. It balances the interests of copyright holders and users of copyright material. And it's in the interest of IP holders that people understand the law and the law makes sense. As I said before, a lot of people sort of think, well, what the guys at Men at Work did with Kookaburra, that was a tribute to the song, surely that was okay, but it's not under Australian law. In US law it would be okay. It's very likely that would be fair. In fact, I don't think it would even go to litigation. It's much more likely that it would just go through to the keeper. And so if Australia wants to improve its IP output and become a net exporter, it does need a flexible fair use defence to encourage innovation. So things like the Optus TV Now system, that is more likely would have got up under a fair use type of defence. I mean, it may not have, but it certainly was a lot harder to make out the time shifting exception. So, and like I said, if a big company like Optus can't get something up, an independent application developer, you're in a whole mess of trouble. Copyright laws are very expensive, and often people will just not do it because it's just too hard. So that's all I've got time for today. Happy to take questions.
Yeah, my question, there seems to be two sort of different factors at play. One is the rights of copyright holders, and one is the sort of the value of intellectual property. You sort of made an assertion there that a fair use clause would enhance the value of intellectual property for software industries and things like that. So it's not just consumers that benefit.
Oh, absolutely.
So there seems to be, if the government's interest is in supporting business, there seems to be an argument that business would benefit by the increase of value in their intellectual property under a fair use. Has there been any work done on sort of quantifying the value of intellectual property that a fair use clause would bring?
Okay, so the question was, has there been any work on what value to business a fair use defence would bring? I'm not aware of it. It wouldn't surprise me if there has been. And I think the point that you make that there will obviously be good value to the software industry for this sort of defence is probably a valid one. But the government often, I suppose, whose value? So you've got to weigh it up, and I think they tend to be a little more happy to look at the value to the US movie industry and the like than software developers in Australia. That's just my opinion, of course, but I think that's more the problem. Yeah.
So we seem to be modelling more and more of our law on what the US is doing, but we're fighting against the notion of fair use, which is common practice in the US. The Canadians have a law that seems to look like what we have, and they seem to be having a great relationship with the US. So why is this a big deal?
Okay, so the question is, why is the introduction of fair use such a big deal when we seem to be following the Americans as far as their copyright law is concerned? I suppose the Americans have had it for 170 years, so it's quite a well-known doctrine in the US, and generally the US likes to export the bad parts of its copyright law to other people, not the good bits. I think that's probably why it's quite controversial. As I said, the arguments against fair use I think are fairly weak, but there are powerful interests lobbying against it, so I think that's really what the problem is. Ian?
You mentioned business and consumers along the way. It's not specifically new science, I believe, but I've long kind of, in my mind, have a protection against that terminology, because in some cases, when one refers to business, it seems to actually only mean a very specific subset of big businesses with some vested interest, just like Disney, that kind of stuff. And at the same time, many people or organizations or companies that actually could be regarded as consumers are actually content producers now, and with the internet and so on, that's even more the case.
Yep.
It's actually a very fuzzy thing, and not being too restrictive about use actually helps everybody, and that could be small content producers.
Yeah, that's true. Yep. So the question or the comment was that the dichotomy of business and consumers is not very precise, and that basically there are a lot of businesses that are also consumers and content creators. I suppose that the distinction I was trying to make is intellectual property holders and consumers of intellectual property, which is a bit of a mouthful. So, but yes, you're right.
But I think that point Arian is trying to make is that the consumers are now also content creators, so they are intellectual property holders in their own right. I think that's what you're trying to say, that they're merging.
Yes.
That it's not Disney that's the intellectual copyright, the IP holder. It's small enterprises that are also IP holders.
Yes, and I think that's a very strong argument for why we probably should have a fair use exception.
It seems artificial.
Yes. Subsidy?
Well, just to follow up to that, for the news media, I mean, in New Zealand there's a news reporting exception, but I mean, news media around the world is always very keen to take the latest video off YouTube or photos that someone's taken of something amusing and put it on the front page of the paper. and in many cases they do not get permission, they do not pay the original photographer, and yeah, whereas if you did turn it the other way around and started ripping off their photos in their paper, they're very quick to come down on.
Yep. Okay. So
the my other follow-up is in current newspapers and that where they're online, that stays online forever.
Yep.
It's not just printed once and given away.
So the comment there was that there's a news media exception, and news media quite often troll YouTube and Facebook and that sort of thing for photos that they use in their news stories, and that if it was flipped around and we were using photos that they had taken, they'd come down on us hard. Well, unfortunately, that's just the nature of the way that law often works, that people who don't have a lot of resources aren't able to sue. But the thing is, they are still bound by the law. So if they are making use of someone's Facebook photo for the purposes of news and reporting, that will fall under the exception, but it still needs to be fair. They can't just sort of use it and exploit it for commercial gain, and it's still got to be a fair use of it. It's really up to the copyright holder then to sue. Obviously, news organisations are more likely to sue because they've got lots of lawyers. That's just the nature of the beast. Yes?
At the start of the presentation, you mentioned the INET case.
Yep.
What effect has that had on this kind of copyright law?
It's not really to do with fair use. It's to do with secondary liability of ISPs, of intermediaries. I just mentioned it because it's one of the three cases. It was one of the things that the ALRC also looked at. And it's also one of the things in the TPP. The TPP actually has specific things in there that say that you need to have better secondary liability of ISPs, which is not a good thing, in my opinion. Any more? Yes.
Sorry, just a follow-up to Simon's comment before about the media in Australia using individuals' content published online and putting that in news, and there being a perception that they can just get away with that. I actually know a few people who have had that happen to them. If you make enough noise to the news agencies, they will pay you because they don't want to get taken to court.
This is true, yeah.
And I actually know quite a number of friends who've had that happen, and they've made enough noise and they've actually been paid for use of intellectual property. Admittedly, close case, but if you pressure them, they will.
So the comment there was that where news media have actually used photos, people who have kicked up enough noise, that news media will generally pay you. This is true. They don't want to be involved in litigation. It's often quite cheap to get a license for someone's photo, so they're much more likely to go down that path.
Just a kind of follow. Business has copyrighted things, and also small businesses too. But now everybody is a content creator. Anybody who's got a mobile phone and uses Twitter is actually a content creator, and anything that they publish online in the copyright law, they have rights in. So, I think the whole notion of intellectual property is complete bollocks. But leaving that aside, we're all content creators now, and we should all get the same protection and balance under the law that the big rights.
Yep. Okay, so the comment was that we should all have equal protection for our copyright. We're all content producers now. Yeah, that's what a fair use exception tends to allow. It works both ways in the sense that, I might write something and someone might like that and take it and transform it, and that might be a fair use of that material, and it might be a huge business that's doing that.
One of the strengths of the GPL is its linkage with copyright. Does the lack or the provision of a fair use clause in a nation's copyright laws have any implications on that?
Okay, so the question was, does fair use have any implications for GPL licensed software? Not specifically. I think it would be very, very difficult to make out a fair use defence of taking someone's code and sticking it in your own and saying that's a fair use. But that's a defence that's open to you. The fact that you do accept a licence when you take that material complicates that quite a bit. So I'd say qualifiedly, no, it doesn't.
What is a non-consumptive use?
So it's a use of material that you don't consume. So I suppose where you take a photo and you just republish it, that sort of thing. It's a bit hard to explain, but yeah, it's like that, where you don't actually use it for anything, you're just basically replicating.
I'm just wondering, from very early on in your presentation, there was a line on satire.
Yes.
How is that defined? Because things like memes often very quickly go into the realm of satire. Majority of them may be. You could even make possibly a wild one and say that the Kookaburra Down Under thing, the whole song is kind of the caricature, stereotype. So is that actually satire as a whole, and therefore kind of falls in there?
So
maybe a wild one, but with memes definitely.
So the question was basically, what are the limits of the parody and satire exception? Yes, that argument was made. No, it didn't fly. And there's been a little bit of litigation around parody and satire, but not a lot. It's generally the ordinary use of the word. So yeah, a lot of memes would fall under satire, or certainly would fall under parody. But you need to go to court to test it. It's not an easy one to work out, which is why fair use is better. Ben?
It's really interesting because it's news to me that we didn't have fair use. So I'd always assumed that if you had 10 or 20 lines of code, that code, it wasn't worth putting a license on because it could be just reused under fair use. Does that mean that code can't be reused? Is there any exception that allows that code just to be reused without using the license provisions that
code is difficult. It would need to be a whole or substantive part under the current regime. Fair use of code, I think it's quite highly problematic because one line actually does something. It does quite a bit of things. So the sort of whole or substantive part, it's going to be a tiny, tiny amount and probably none at all. So I think with code, you really are getting into the realm of licensing. So you either got just copyright on it, so it's my copyright and you need a license, or you BSD it, or you GPL it, or whatever myriad of licenses that there are out there.
May I just add something to that? Because I dealt with this kind of stuff at MySQL in terms of bug fixes and that kind of stuff. Like 1 or 2 line things, is that copyrighted? As it turns out, it is different in different countries. So in some countries, that 1 line code is actually technically copyrighted. So if someone wishes to make a contribution that is actually only a couple of lines, it would be useful to actually specifically state a short line, it's okay for you to use it, and I kind of don't care about copyright for this, because in some jurisdictions it might otherwise be issued.
Okay, so
the company may say, yeah, can't touch it.
So Arjen's comment there was that in some jurisdictions it's quite, the substantiality test is quite different, and that's true. And yes, if you are going to just contribute 1 line of code, you probably should have some form of release or license or the like on it. And I think that goes with anything really. I mean, if you're going to produce some sort of copyright material that you see that has value, you probably should license it in some way, because then everyone's square, rather than sort of relying on fair use or substantiality or whatever. Yeah. Any further questions? Right up the back. Oh. Oh yeah. Oh, have we?
Yeah.
Oh dear.
Yes. Sorry, I've been holding up the phone.
Yeah. Oh, sorry.
Anyway, so okay, I'm sure that Ben will be available for people to talk with after. And can we all thank Ben?